Fired Up. I'm your host for the show, Bob Irwin. We are coming to you live from Las Vegas, Nevada. We are in the law office of Alan Butel, attorney in downtown Las Vegas. Alan lets us use space in his office for the broadcast and frequently appears on the show. He is a general attorney who does criminal defense and civil litigation and is actually a frequent guest on our show. And a good attorney, if you need an attorney, then and you get involved in a shooting, you certainly need an attorney. And we got another one over here to my immediate left that does that too. This show, Fired Up, is all about guns, politics related thereto, a lot of that tonight, and self-defense issues. Fired Up is on radio at KSHP 1400 AM. They rebroadcast this video show on Sunday mornings between 9 and 10 a.m. So while you're getting ready for church on Sunday, you can tune us in and listen to the show while you're driving to church, 9 to 10 a.m. on KSHP 1400 AM. It is actually broadcast streamed live worldwide. So the YouTube version that you're watching now is available 24/7 and stays online forever. Today's guest is Nevada and California firearms attorney, general attorney and firearm specialist attorney, Donald Green. Don, if you would, a bit of your background for anybody who is not familiar with you.
Okay. Well, thanks again, Bob. And first of all, again, it's an honor to be on your show and be associated with you and your staff and all the other members, all of your other guests. Again, my name is Don Green, and I've been a lawyer in California and Nevada over 33 years. Emphasis of my practice is criminal defense and gun cases, civil, criminal, FBI appeals, concealed weapons applications, consultation to federal firearms dealers, and analysis. And I do write on some blogs concerning recent cases and some activity. You can find me at dongreenlaw.com, and my cellular and office numbers are on there. Thank you.
All right. If you lose any of that on the website, Fired Up with Bob Irwin, there is a list of the attorneys that we have here and their contact information. My contact information on the back there, bob@firedupmail.com, is at this moment not working. So, but the phone number is just below it. So if you need to get a hold of me with a question or a comment on the show, you can leave a message at that number, and I will get back to you within a day or two. In any case, a couple of things up front. We talk about some defensive firearms use cases on the show each week, and we are using rational responses to what people would normally do in home invasions, things like that. And I pick out cases that are appropriate for the learning experience. I usually leave the names of the people involved out of it, because the idea is that you would look at that instance and see what they did and learn from it, what they did right, what they did wrong, how they could have made it better, you know, maybe another warning or maybe not open their front door or whatever the case may be. But understand that if you're actually involved in a shooting, you need to hire an attorney in the state that you live in to look at the case for you, because the law varies from state to state a lot. We frequently, when Don is here, we do some California cases that would be bad shootings in California and good shootings in Nevada and so forth. It really depends what the rules are where you live. So if we try to be informative and keep you out of jail and keep you out of civil lawsuits. But if you have an actual case, don't rely on what we're telling you on the air in the general sense as being correct for your case. As I always say, what's a good shooting here in Nevada is a bad shooting in New York City. And between those two extremes, there are all sorts of in-betweens. So if you got a real case, get a local attorney. And if you can't find one, I can, don't give me a call. I can recommend somebody for you in most states. But you need a criminal defense lawyer that does gun cases. This is from the New York Post on the 28th of June this year. This is in New York again. So this is a New York shooting. A customer walked into DF Brothers Sports Center on New Ultrich Avenue in Bensonhurst. That's a section of Brooklyn, New York. I know most of you didn't think there were any gun shops in Brooklyn, but there actually are. Highly restricted, but they're there. Anyway, the shopkeeper had this guy walk in about 11 in the morning and wanted to see some guns. The shopkeeper is a 60-year-old former U.S. Marine, asked to see the guy's gun permit, because to buy a gun in New York, you have to be
Apparently, yes.
approved, yes, and have all your paperwork before you go get the gun. The guy instead pulled out a can of pepper spray, chemical mace actually by brand, and sprayed the owner of the shop in the face. The customer, now the robber, then used a hammer to smash the display case and tried to steal some guns from that display case. The robber was forced to retreat when the shop owner, the merchant, came up with a shotgun. Police say the injured suspect ran out of the store, leaving a trail of blood behind, but they could not say for sure whether he was hit by the shot or he injured himself when he smashed the display case glass, which either way. No arrests have been made as of this report. The workers at the shop declined to comment on the incident to the media, which is a really, really good idea. You're in really in the woods in Brooklyn, New York, I would assume, on a case like this. This is a good shooting by all standard scenarios for self-defense. I wrote in my notes, with the possible exception of New York City and a few other places that coddle criminals, and of course this took place in New York City. In common law enforcement training, most of you know I've taught police academies for years and years, and if you are sprayed with pepper spray, this is instruction for law enforcement officers. It leaves you in a position where you're probably blind for a few seconds or can't breathe for a few seconds. And if you get in that position, the criminal can take your gun, and if he takes your gun, in all likelihood, he will use it on you. So I'm assuming the owner of the store was alone, because certainly other employees, if they were there, would have engaged the robber as soon as the pepper spray came out, yes. And nobody did. The guy was on his own. So either we need some new employees or he didn't have any there with him. But the deadly force, what I'm saying is deadly force rationally is a reasonable option. You're in a building full of guns. The display case has been broken already, so the guy can snatch all the guns he wants. Your life is in danger now. That may be adjudicated differently in New York. Media information from the owner's friends. The owner had apparently a lot of buddies who showed up to talk to the media. He was smart enough not to talk to the media, but his friends weren't. The information available is that the former Marine owner, is licensed to carry, which is fine. You thought that was impossible in New York too, but it's not. You can get permits.
Pretty close to it.
It's on the edge. Anyway, and the bottom note here is, of course, never bring pepper spray to a gunfight. If you're a crook, bringing a pepper spray to a gunfight is not generally good for your health. We will follow up on this case if I get more information on it. Cases like this where the shop owner is ultimately okay, the guy is apparently alive and well, they didn't catch him, he was either not wounded at all by the shotgun or was certainly in shape to flee. If he's never caught, we'll never hear anything more about the case in the media, but I'll follow up if we can. What do you think, Don? Is the shop owner in trouble in New York City?
I think that I think the shop owner is going to be all right. We have, in every state, there is some form of castle doctrine. Mm-hmm. And the castle doctrine doesn't only apply to your house, it can apply to an automobile, and with certain exceptions, it applies to your work. So the man is not just faced with, give me some of the guns, give me the money. He's faced with two items which were threatening: pepper spray and the smashing of the glass with a hammer. Now, although the pepper spray might not be deadly force, you don't need deadly force. If it's going to cause great bodily injury, you could be blinded permanently. Right. The focus of this case, the focus here, and for your viewers and listeners, is that the defense must look at the actions and the thinking of the shopkeeper, not the media, not the police, but what did you think at that moment, and what you were thinking reasonable and rational? But you're not always going to have that. You're going to have mistakes. You might forget to call 911 right away. That still does not mean that it's not a good shooting.
Right.
In California, I think it's still a good shooting. In Nevada, it's a good shooting. Again, we're not advocating shooting, but notice also another thing is the shopkeeper asked for that permit to even touch handguns like they used to have in Illinois.
Right. You did it exactly right.
And in California, you know, most people do not know, and I know a lot of attorneys don't know, you actually have to have a pre-approved permit to even try to get a firearm in California. You can't just walk into a gun shop in Riverside and say, I'd like to buy that gun, even though there may be a 10 or 15 day wait. You've got to be pre-approved for it. So this is a good example of a shopkeeper not just protecting his property, but also the threat was against him personally.
Yeah, and he's obeying the law. When the guy didn't have his pistol permit in hand, he told him he couldn't even handle any of the guns. So here comes a hammer, a deadly weapon, and the pepper spray, which can be certainly disabling enough for him to get killed. So I agree. I think it's a good shoot. I'm a little worried because of where it is.
Yes.
But there are gun shops in Brooklyn, and it is possible to get a carry permit in New York City. Apparently, I didn't know there was a gun shop in Brooklyn until I read that. Huh. This is Fox 29 TV. This is on the Fox Channel 29, Channel 29, and on the 29th of June in Okeechobee. Wow, am I saying that right? Anyway, it's in Florida. What are the Indian names? A couple told the county sheriff's office they returned to their home on 138th Street Tuesday evening to find the front door wide open. The report says the husband went in to check things out, only to find a man inside his home. He told 911 when he called, I went in, grabbed my wife's 12 gauge, put shells in it, was quiet as I could possibly be. Then she saw the guy, says, I told him to stop or I'm going to shoot. He kept going and going, meaning he was coming toward the shotgun holder. And the guy said, so I shot him twice. I'm almost positive that I didn't hit him because a 12 gauge would have dropped him right there. That's a quote from the guy. Deputies were called to the neighborhood and their canines searched the area. Unfortunately, they were unable to find this guy. So he wasn't hit so badly that he couldn't flee. It's unclear if the homeowner hit the target, and so the burglar may still be on the loose. We did find, the sheriff said we did find shotgun casings. There was no indication, such as blood, that he had possibly been hit, so we don't know. That was from a sheriff's office spokesman named Michelle Belly. The homeowner described the suspect as white or Hispanic wearing a hood sweatshirt. That'll help. It's hard to recognize that kind of stuff in real life when somebody's in your face. A couple of things here. First off, regular viewers will know what I'm about to say. When you come home and find your front door open, call 911 and wait for law enforcement because they can come and search your house. They have body armor, lots of backup, and free lawyers. That being said, searching for the criminal yourself is an option that's often used, and I realize that. It's your choice, especially if you think you may have left the door open when you left, which is possible. If you think that, you might want to go in and look around, and he did. That's okay. It's his choice. Herein, again, is the problem. I don't think we want to do that. Remind me later. My computer just told me to update the system we're broadcasting. Unlike being in the movies, a 12 gauge shotgun, even with the widest spread possible, a riot gun with an 18-inch barrel, only shoots a pattern of roughly 1 inch in diameter per 1 yard that the target is away from the muzzle. So shooting across a room where you are at 9 feet, let's say, which is a long way in a house, from your muzzle of your gun to the target, the pattern it's going to print is roughly 3 inches in diameter or less. If it's a longer barrel shotgun or has a choke in it, it's going to be less than that. Is it possible? Yeah, it's very possible to miss. You have to actually aim the shotgun at those ranges because it's shooting a very, very small pattern. So it's entirely possible to miss. So the object lesson there is next time you go out to the range, take the shotgun with you and fire a few rounds at 6, 7, 8 feet, and you will see that it makes a ragged hole in the target 2 inches or so in diameter, and it's easy to miss somebody unless you put the gun to your shoulder and aim across the top of the barrel like you're shooting trap or something. Or practice shooting it from the hip so you can hit the target, but it's a small pattern. Anyway, so you need to practice that and see if it really works. That patterning problem separately, whether the intruder's was hit or not, he's hurt or not, it's still absolutely a good shoot. The warnings given and ignored add dramatically when defending any illegal second guessing. He did say that he told the guy, get out of here, etc., and warned him. He had a shotgun. If there is litigation over this, I can't imagine where it would be in Florida because their guns are their laws are pretty self-defense oriented. But the warnings absolutely help because if you can show they were there, it just gives you 10 extra points when you're in front of a jury or a DA looking if there's a crime there. Right? Warnings help.
I'm going to give an opposite point of view.
Okay.
One preliminary observation. Stupid.
Mm-hmm.
If the door is open to your house at night, you do not go inside.
Yeah.
Number one, where is the fear required for self-defense justifying use of great bodily injury or deadly force? Plus, how do you load and rack a 12 gauge quietly? Everybody can hear that in your house.
Yep.
And when you rack that weapon and load it, where is the fear? It's bare fear. It's not that amount of fear needed to defend yourself. And when you go into the house, the homeowner had no weapon. For example, suppose he had his concealed carry permit and went to his house. Maybe there were the grandchildren were upstairs and they just went for a walk. Now that's a different scenario. But I think that if this case was in California, the homeowners at least the husband has a definite problem.
Oh, I agree. If it was under California law.
Maybe even in Nevada, he might have a problem because the issue is, where is the bare fear? Do you remember L.J. O'Neill at the district attorney's office 25, 30 years ago?
No.
Excellent prosecutor. L.J. had a case. You may remember the case of the kid, and I'll just take a second. The kid who shot his father from the top of the mobile home in North Las Vegas, and he claimed self-defense.
Yep.
L.J. O'Neill took that bolt-action rifle in court and pulled the bolt back, slammed it forward, pressed the trigger, pulled the bolt back, slammed it forward, pressed the trigger. The kid was found guilty, but because of his age, the judge couldn't sentence him to life. But it just gives you an example that that is going to be used against you in court when that DA racks that weapon and you try to do it quietly. You can't rack a 12 gauge quietly.
Well, I understand that, and I that's why we have juries. And Don and I could end up on the opposite sides of the case sometime. Hopefully
Yes.
Not. I understand the guy searching his house, thinking he might have left the door open or whatever, and I don't really have a problem with him searching his house, and getting a 12 gauge and loading it, because he's going to search the house. Again, we both agree he shouldn't have searched the house. He should have called 911 and let the police do the job. That's what we pay him for. It's a call on scene, whether you're going to search your own house or not. Neither one of us would advise anybody to do that. Of course, you should call the police first. And like I say, they got all the advantages and all the backup you could possibly want. Once the guys decided to do it, there we are, and that's what the case is going to be. That's how we end up in court. Review Journal reported this one. This was on the 29th. It's here in Las Vegas. I have very little information about this case. I just thought I'd mention it because it's a Las Vegas case. This is at 2 a.m. A homeowner in the 7700 block of Prinese Lane, that's near Blue Diamond Road, awoke to the sound of breaking glass and retrieved a handgun. He fired several shots at a male intruder, apparently striking the guy twice. The intruder fled before officers arrived. University Medical Center later reported to the police that a person with 2 gunshot wounds had arrived at their emergency room. We call that a clue in law enforcement work when it's 2 in the morning and the guy fires 2 shots, and then somebody shows up 20 minutes later at the emergency room with 2 holes in him. His injuries were not considered life-threatening, according to LVMPD spokeswoman Laura Metzler. The juvenile suspect will be charged with conspiracy to commit a home invasion in connection with the incident. The only reason this is a pretty open and shut case, but I brought it up because, one, it's a clear, we're having a lot of home invasions here in Las Vegas now. It seems like there's one every day. Having a firearm and the will and the skill to use it saved the day here. Obviously, if this guy had not been armed, bad things could have happened. The details of the distance, the warnings the home invader got, we don't even know if the home invader was armed in this case. So a lot of stuff will come out later in the investigation. I bring it up because we have another juvenile home invader. They're getting younger every day. This is part of our problem. They didn't give the age, but he's clearly something under 18, or we wouldn't be having this listed as a juvenile crime. So we will discover later on when I follow up on this what happened. But it's just one of those things. 2 in the morning, somebody's in your house. Is it reasonable for you to pull your gun and fire? Yes.
May I make one observation, Bob?
Sure.
It comes out of your training in your classes. Every week when you taught for hundreds of classes, that is that when you shoot somebody in a home, this is from the legal standpoint, when you shoot somebody in your home, you cannot assume that that person is dead.
Yes.
I looked on Google Maps from the Pyrenees, the 7700 block of Pyrenees Lane near Blue Diamond is 14.7 linear miles from University Medical Center on West Charleston in Las Vegas. So this intruder, although his wounds are not life-threatening, traveled that distance. We don't know the time. We don't know if he had help.
Right.
But still, there's an intruder. Suppose that the intruder, decided not to go to the emergency room, but to come after you. We've got an intruder who traveled that far. I'm not advocating killing people every time they come into your house, but you cannot assume that just because you shot somebody that they are disabled.
Right. They're still a threat, and that is one of the problems. Is everybody that I've talked to almost gets their training from television, and you shoot somebody anywhere with a .22 and they fall over, blood comes out of their mouth even if they're hitting the toe, and make a little speech about tell Laura I loved her, and then they die. 90% of people shot with a single round in the torso currently are surviving, partially because of medical care and so forth, but you're assuming that it hits a vital organ. There's lots of places to put a bullet through somebody where it really doesn't cause a lot of damage, where they're not going to be in serious physical trouble and can still fight. I just put that in because it's another juvenile, another home invasion, and what are these guys doing at 2 in the morning breaking into people's houses? It's ridiculous. Want to mention Grant Defense. They're at 5580 South Decatur. That is the corner of Russell and Decatur. It's right by the Dewey Animal Shelter. Their Dewey Animal Shelter is their back door. They manufacture AR-15s here in Las Vegas, build AR-15s and some custom Glock pistols, modifications of Glock pistols. You ought to go by there and take a look. Really nice guns. And if it doesn't work, it will work, of course. The manufacturers don't care. You don't have to take it back to somebody else. I love to buy things from somebody who actually built it. I can go beat on his head if it doesn't work. Actually, Grant makes great stuff. You need to take, if you're looking at buying a Glock 19, you need to go by and look at the ones he modifies before you spend the money. WAVY TV 10 on your side, as they call themselves. On the 26th of June in Virginia Beach, police say a suspect robbed a 7-Eleven in the 300 block of Kellam Road. Officers were called to a reported robbery at the convenience store at 1:06 a.m. Police say when they got on the scene, they found the would-be robber with a gunshot wound in his upper body. He was taken to the hospital in critical condition with life-threatening injuries, but now it appears he will recover. On a story that came out about 24 hours later. The wounded robber has been charged with 2 counts of robbery and wearing a mask in public, which is apparently a crime in Virginia Beach. I don't know if that's a crime here. Anyway, 10 on your side dug into his criminal history and found he had been arrested 3 times for robberies. He pleaded guilty in 2006 for 2 counts of robbery. Record show he was also charged with a home invasion on East Bay Shore Drive in July of 2016. He spent several months in jail. Then in December, he was allowed to bond out. The Commonwealth Attorney's Office tells 10 on your side they argued against releasing him on bond, but the judge granted it. The suspect now is scheduled to go on trial on these charges in August. The reason this is here is just to yell at the legal system. This guy obviously is a career criminal, you know, and even though the Commonwealth attorney argued that he not be released on bond, the judge did it anyway. Makes me wonder how many more crimes this guy might commit before the trial date in August. I don't know. You know, will this guy show up for trial? Who knows? He may just run and we'll never find out. I'll try and follow up on this, but when I see a guy with this kind of violent criminal record, all in rapid sequence, I'm assuming judges are in Virginia Beach are elected. I don't know about, are Virginia judges elected? Do you know that off the top of your head?
I don't know.
But anyway, when this guy comes up for re-election, if he runs, I can see this this being a real problem.
Most
How
definitely.
to release a guy who's doing all this kind of stuff, and these are all violent crimes, and he let him bond out. You don't have to comment on the legal system because you got to.
No comment.
You got to talk to judges.
No comment on that one.
This is 40/20 News. They're 2 stations that work together, or the same broadcast on different types of media. Their on-demand reports on 6/25/17 in Spiro, Oklahoma, that around midnight, a woman and her husband were in their living room when the front door swung open. They called out as they thought it was her father coming home, but nobody answered. They walked toward the entrance to their home, and they noticed an unknown man walking into the house. The woman was able to grab her gun and stop the man. Apparently just pointed at him and told him to stop, and he stopped. She took him then outside. They called 911, and police were able to quickly respond. The victim told 40/29 News they normally kept 1 bullet. I presume they mean a cartridge or a shell if it's a shotgun in the gun, but the husband told her after the incident it was completely empty. The man was arrested after the incident. His name has not been released as yet. The object lesson is a note to especially couples: be on the same page as to whether your house guns are loaded or not. Had this guy resisted, the woman would have got a big surprise, would have heard the loudest click you ever hear in your life when your gun doesn't go off. There are many instances that I've run across over the years where people go to the range and they clean their gun when they come back and they forget to load it. or if there's two people in the home, they move the gun from point A and decide to put it at point B. Right after this show's over, that would be a good time while you're thinking about it to go check your house gun or guns to see if they're where they're supposed to be, if they're clean and oiled, and if they're loaded. Keep your hidden guns in your house in the same place all the time, so you don't have to think about 3 o'clock in the morning. When did I leave it? Where did I leave it this time? I usually put it in the drawer. Sometimes I put it on the kitchen's, whatever. Leave it in the same place where you know where it is, because you're not going to have time to think about it when the guy is in your house. And make sure it's clean and lubed and loaded. I had a story I've told several times on the air, but it's been years. A friend of mine in New York PD, they have a system there where once a year you go to qualify and you shoot up, at the time anyway, you shoot up your ammunition you've been carrying, and then they issue you a new 30 rounds. And this was a detective, and he has a little 6-shot revolver at the time. And they give you 30 new rounds, and you reload your gun with your new fresh ammo as you leave. And when he went back the next year to requalify, he went to the firing line and went click. After he left the range, he had never reloaded his gun. He'd been carrying it empty for an entire year, pointing it at people, yelling, drop the gun, all sorts of things. And he never had any bullets in it. Not a good idea. Go check your gun when the show's over. Literally, go look and make sure it's loaded and operable and it's where it's supposed to be. And if there's more than one adult in the house, that you both know where it is, right? Rules to live by.
Yes.
Live by.
But, Bob, real quick on this instance here in Oklahoma, how do we distinguish this case from the Florida case just a few moments ago where I said stupid? Key distinguishing feature is that in Oklahoma, they saw the intruder walking into the house.
And they were in the house.
In the house. In Florida, they're coming home and didn't see anybody at that point. Plus, the woman had the presence of mind, even though nobody knows exactly how many cartridges were in that weapon, threw down on the guy and held him at gunpoint until the police arrived. There was no shooting. But it just goes to show, and you've got 2 examples in your packet today. It just goes to show that you don't have to shoot somebody under these circumstances.
No. So most bad guys, we're in the area of something around 90%. If they have a gun pointed at them or are warned verbally, I have a gun, get out of my house, 90% of them leave. These common cases of people not actually shooting are extremely common. They just don't make the media, because if there's no blood, they don't put it on the TV. Don't write about it in the paper. Jerry Creed, attorney, a friend of mine. He does elder law predominantly. He's out in Summerlin. He also does Class 3 trusts. He does firearms trusts and Class 3 trusts. As I mentioned the last couple of shows, the trust things are in absolute flux right now because the ATF is making all kinds of new rules for trusts and how a trustee can be appointed and so forth and so on. Without going into all the details of it, because it would take the rest of the show to even touch the surface of trust. But if you have a firearms trust where you're going to use it to pass your guns along to your heirs, or particularly a Class 3 trust to pass along machine guns and sawed-off shotguns and so on to your heirs, it's gotten really complicated. If you have a trust that was written more than 6 months ago, you need to have it reviewed. Right. The laws change. I know you do some of those, do you not, Sean?
Well, let me tell you what we do. We get the cases where there's a problem after the trust has been supposedly obtained. Guess what? On the internet for like $199.99.
Yeah.
Don't do it. Go to a qualified lawyer. Go to Mr. Creed if you're in the Las Vegas area, or call his, if you're in California or some other state, call his office for referral.
Yeah, Jerry can do that. The firearms trust period, Class 3 tests are kind of federal things anyway. I don't know. They probably do get bent by state law, though, don't they? I don't know. You'd have to ask him. But anyway,
right.
Jerry's telephone number, he's in Summerlin. is 702-806-7777. Got a lot of sevens in this thing, like other lawyers that I know. Anyway, if you give Jerry a call, I'm sure he would be happy to look at your trust and get it updated, or at least give you an opinion. You ought to go back to the guy that wrote it and have it updated, because it has changed dramatically. If you've got a firearms trust and your attorney that wrote it hasn't called you in the last 6 months and said, you need to come in and have us revise that,
yes,
you need a new attorney, because it's got to be out of date.
Yes.
Got to be. This is from, let me see how we're doing on time here. Oh, we're good. We're 35 minutes. This is from the Gazette and ABC TV News. We're on number 6 now. In Colorado Springs, Colorado, the Gazette, I have to tell you, because I just was amazed. Their masthead said, published since 1872. So they've been won a couple of Pulitzer Prizes and all kinds of things. How many businesses have been in view since have been publishing for 100 and wow, yeah.
I only know of your office.
Anyway, a jury in Colorado just acquitted a Green Beret of negligent homicide for fatally shooting an intruder in his attached garage. This case really gets a lot into the woods of legalese, and I'm only going to hit the high points, but you can pull up the story from the Gazette in Colorado Springs. It's like 14 pages of stuff. This is really involved. I assume you looked at it when you saw it there. And
two brief points after this.
Yeah. Anyway, the encounter happened in a garage that is not attached to the house. It's 25 feet back from the shooter's main house. When he was outside, he saw his bicycle laying in the backyard and went over to investigate. Understanding that under Colorado's castle doctrine, residents are permitted to use force against intruders, including deadly force, if they reasonably believe the intruder's intent is to use any degree, that's what the statute said, of force against them. The prosecutor's case hinged on the interpretation of Colorado law, which provides legal protection to homeowners who use deadly force against intruders. Those protections are limited, though, to buildings usually used by the person for habitation. Now, this is a unattached garage that's 25 feet away, without getting into all this crap here. He was found not guilty. This is a really complicated case. If you want an education on the castle doctrine and how this gets into the absolute weeds, this is the way their castle doctrine is written. It's got to be the Lawyers Full Employment Act.
Yes, it is.
It is absolutely. He knew the intruder. The guy was a drug addict who had turned his life around, and then he fell back into drugs. He was living on the streets. The prosecutor even said, we believed in our case. We believed in our case. We respectfully disagree with the jury's decision to release the guy. I wrote in my notes, there's too much here to even begin to talk about it on air. This was a really, really close case. And my best comment was, this is the Lawyers Full Employment Act.
Yes. Your listeners and your viewers need to take a look at this case.
It is.
And you did report it on the Gazette in Colorado Springs on June 26, 2017, 10 days ago. 2 observations. Notice that the prosecution's case focused on the interpretation of the law. They're probably arguing this to the jury, all this esoteric stuff. And notice what the defense did. The defense kept the case simple.
Right.
That the intruder lunged for the resident's pistol in the dark, forcing the homeowner to defend himself. The intruder was shot 3 times in the back. Yes. As he was supposedly trying to escape from the garage door. Now, I know that in California, the Green Beret is going to be doing like 25 to life at Pelican Bay. There's no question. In Nevada, probably a close issue. Colorado was close, but the thing is that your viewers, your listeners have to, when there's a shooting, they have to make the case right there, articulate the facts right there. Don't embellish. Keep it simple, and that's what the defense did in this case.
Yeah, there was the other issue in the case was the 3 rounds hit the guy beyond center line in the back. The Green Beret is firing in the dark at the motion. Could he see the guy had turned? You know, I argue this in court a lot of the speed it takes somebody to turn versus the guy firing. This is in the dark and so on and so on. But that was the second issue. Did he shoot him in the back when he was trying to flee? Could he have seen that he was trying to flee, et cetera, et cetera? Plus, did it fall under the Castle Doctrine? So they defended the case on self-defense, not on the Castle Doctrine, because of the questionable just whether the thing was attached. One of the things that I read here, and I put it here to get your comment on the bottom, the last comment about they said when it came to the jury decision, one of the jurors showed up for the closing arguments wearing a shirt that said Army on it. The guy is a Green Beret, the defendant. What does a judge do with that? I just was, it's like a biker's on trial and you wear a shirt that says God bless the Hell's Angels when you're on the jury, you know?
The judge could have said, hey, you need to get another shirt. Or, the prosecution could have said, there's no basis for mistrial. It's only a shirk.
Yeah.
Now, if it said, let him go free, or whatever this guy's name is, that they believe him, then the juror already has some preconceived notion of how he's going to vote. But I think that the T-shirt spoke for itself as to how that juror was going to vote.
Yeah. If you're on a jury, don't wear your pro-gun or anti-gun or whatever shirts. Dress. Don't let anybody guess your politics by what you're wearing. That is just, it must have been, I don't know, the judge is stuck. I mean,
yes,
he can't, but he wanted to show his support for the defendant.
Exactly.
Apparently, it wasn't an accident that he wore a shirt that said Army on it. Anyway, I'm gonna skip 7 so we can get into this San Diego case. One of the bits of commercial, always talking about training. If you carry a firearm, CCW, you keep one in your house. We've already been through a couple of cases tonight where you realize a little bit of knowledge can save you a tremendous amount of money and time and so forth. Where the store I used to run, I'm retired from the gun store, as regular listeners know. They still teach the concealed carry permit and renewal permit classes 3 times a week. Monday, Wednesday, and Saturday. You can call them at 702-454-1110 or sign up online at thegunstorelasvegas.com. Good class. I know the guy that wrote the lesson plan. He's not only good looking, but really bright. Get some training. It's amazing. If you listening to this show, if you've gotten a couple of glimpses tonight of, wow, I didn't know that, and you're about to get a couple of more here. Lots of law changes. Get the training. It's going to take, you can sit in the class. It's, I think, $55 for the renewal class. It starts at 9, and then they go home around 2:30, and then or 2 o'clock, and then the other people that are there for the whole class get through about 6 o'clock. It's going to take a day of your life and cost you $75. That includes targets and ammo and everything except the state fees. Get the training. It will save you a tremendous amount of heartache later on to learn the rules. ABC News, the national network, reported this week in San Diego, California, a federal judge on last Thursday blocked a California law that was to take effect Saturday that would have barred gun owners from possessing high-capacity ammunition magazines. The high points of this are that if you live in California, you had grandfathered magazines. You could have gone to the state and said, I own these 7 over 10 round magazines to fit this and this, and register them with the state. Then the state changed their mind. And they had a law they'd already written that was going to go into effect Saturday that said those grandfathered magazines are now contraband, and you have 30 days or 6 months or whatever to turn them in to the government or destroy them or sell them out of state. I remember that when this came up, I told everybody to bring them up to the gun store. We'd buy them for $1 a piece, so you don't go to jail in California. Anyway, several of the gun groups got a lawsuit going, got in front of a federal judge, and he said, wrong, you cannot take these from people when they legally purchase them and register them with the state, and now you're basically stealing their stuff. So he put, his name is District Judge Roger Benitez. He issued an injunction blocking the taking and will consider the underlying lawsuit filed by the NRA, California Rifle and Pistol Association, several other groups. Obviously, the questions, now you're okay if you have registered standard capacity magazines in California. If they weren't registered, you can't register them now. They've been illegal for years. And my question was, and I found it later after I typed my question to you about does that mean they can import magazines again to California? The judge said no. That was in his decision, I guess.
Yes.
But
if you have them,
if you have them and they're legal, they're legal. Charge on. I don't want to get in the woods on this thing. This is another one of these look out, folks.
This case is Duncan versus Becerra. Becerra is the Attorney General of the state of California. Duncan is a woman who, along with the other plaintiffs, owned several high-capacity magazines. The lawsuit was filed in May 2017. The briefing was done on an accelerated basis because the law, as you point out, in California was going to go into effect on Saturday, July 1st at midnight. That is July 1st, 2017. In the briefing, which we have every single document filed in this case. The briefing on both sides is admirable from the state of California and Duncan's attorneys.
This is Don's briefings from this case. He does his homework.
Now, why is this case different from the case decided by the Ninth Circuit in Fayok versus City of Sunnyvale in March of 2015, when the United States Court of Appeals for the Ninth Circuit said that the City of Sunnyvale can properly regulate the sale of high-capacity magazines. The distinction in Fayok is Fayok was selling the magazines. In this case, Duncan and the others already possessed them. Yeah. And regardless of whether the magazine was $100, $500, or $1, Judge Benitez, who was appointed by President Bush in the early 2000s and went to a regional law school in Southern California, decided on a property issue that you can't take this. This is under the takings clause of the Fifth Amendment to the Constitution of the United States. And because Judge Benitez believed that this was a Second Amendment issue, that you cannot properly utilize the firearm, that is the AR-15, for its intended use without a magazine. And the way in which California had gone about this was improper, and he issued the injunction on Thursday, June 29th, 2017, and became effective, we thought, throughout the state of California. if things couldn't get weirder, and this is what, and I have a lot of respect for the NRA, but they missed something. On the same day, in the United States District Court for the Eastern District of California in Sacramento, a federal judge issued an order denying an injunction on the exact same statute. And that case is Weiss, W-E-I-S-E, versus Becerra. It was published and decided on June 29th, 2017, on that Thursday. Now, I believe that they were both set out on Thursday, probably coincidentally, but they were put out on Thursday because the law was going to take effect at midnight from that Friday, and they're going to get tons of press and maybe get one day in which they can either keep their magazines or dispossess themselves of the magazines. So right now, although we have a lot of news coverage on the Duncan case from San Diego, which you just spoke with Judge Benitez, we also have another Bush appointee who issued the decision in Weiss versus Becerra on the opposite. He took an opposite approach and said that this was a proper regulatory function of the state of California, and that there was no plain and viable use of these particular magazines which would fall within the Second Amendment, and therefore the regulation is proper. So you've got conflicting decisions. And what's the decision? What's the difference between the two judges? Both were appointed by President Bush around the same time. Well, Judge Benitez in San Diego went to a regional law school, Western State University College of Law, which used to be in Fullerton. And the judge in the Sacramento case went to UC Berkeley, Bolt Hall, for his law degree. So that's telling you something right there. But right now, the blogs, with at least the attorney blogs, there is confusion which has been created by these two cases. And I highly recommend that your listeners go online and speak to the attorneys in their area. They're welcome to call me. Just go to dongreenlaw.com. You'll see our cellular and our main line, and we'll talk to you. But right now, question: can I, average citizen in California, who own an AR-15 and let's say a 30-round magazine, even a 20-round magazine, can I legally possess that firearm based upon California law, which went into effect on July 1st, 2017? The answer is yes and no, depending on which judge and where you're going. It's setting up a showdown in the Ninth Circuit. We know that Peruta was denied certiorari by the U.S. Supreme Court just a week ago on the 26th, with Justice Thomas giving a blistering dissent, joined by Justice Gorsuch. Now, all that means is that I know that probably Judge Alito, who was in the majority in both Heller and McDonald, and I know Judge Alito probably wanted to hear that case. But what about Peruta? Why didn't they hear Peruta? It's coming out of San Diego. Why? Because Peruta did not have an injury. He didn't have a CCW. He wanted to get one. So it's supposed that Peruta or Bob Irwin has a CCW already, and you're going for your renewal, and there's a new law that says you can't have it because you can't meet this other criteria. And you're going to say, wait a minute, that's a valuable property right, like a driver's license, although you can regulate it. So it's setting up a showdown.
Yeah, this is a common thing that you need to understand about the legal system. In order to try and overturn a law to sue, you have to be harmed by that law. You can't just be an innocent bystander that thinks they ought to change the law. So that's part of the problem. And for historical purposes, this magazine thing in California goes back years and years and years, where they tried to outlaw guns that capable of holding more than 10 rounds, and that didn't fly. So in several courts, so they decided then to outlaw the magazines. So they knew had these top-loading AR-15s and all this kind of stuff, And their courts held, and the Ninth Circuit held, that a magazine in of itself is not a firearm, therefore they could regulate it. They wouldn't let them regulate the guns themselves because of Second Amendment issues, all this kind of stuff got into the woods. So they simply outlawed the magazines. And that's how we got into this crap in California, where you can't have a magazine, and it went through because it wasn't a Second Amendment issue, according to the courts. It's way more involved than that. But this is going back 20 years, and that's how we got to where we got. That's why you can't import them into California. This law, these decisions, even the one we like, didn't change that. You still can't buy them and sell them between each other. This only affects the people that already owned a magazine and can prove it because it was registered with the state. If you had a 30-shot magazine, which one or two people in California probably do without telling the government about it, it didn't affect yours. Yours are still illegal because this is only for registered ones. This will end up at the U.S. Supreme Court. There is no doubt. Some of the blogs I read said that they thought the Supreme Court was waiting for a cleaner case
Then Peruta.
Part of it involved somebody having a domestic violence in their background or something. There was some other issue there that kind of soured the case. I may be thinking of the wrong one. So disregard that. Probably wrong. The second issue is actually, we've touched on it already. The Supreme Court declined to review the California May issue permitting the Peruta case. So we already talked about that.
Yes.
And that will go to the Supreme Court when we have a cleaner case, I am sure. We're just up on deadline here. I want to mention that Channel 3 News and Associated Press, for all of you that go out and shoot in the boonies, on the 30th, the U.S. Forest Service issued a temporary shooting ban for the public at the Carson Ranger District due to the fire danger. That covers a lot of acreage in Nevada. The headquarters is in New Mexico, but it's the fire danger area. That district covers more than 625 square miles in Nevada and California. People are prohibited from shooting in the district between June 30th now and September unless they are hunting. Forest Service says there have been 9 fires in the region where target shooting is expected or suspected, and you can actually go to jail if you're out shooting in the area and you don't have a hunting license. They're worried about people firing 50 rounds out in the boonies, not the guy who fires 1 or 2 rounds. They've had a couple of these fires. We're having all over traced to them. If you wish a map of where you cannot shoot, I tried to get one. The Forest Service sells the maps for $10 each. So you can call them at 575-758-6200.
Where did you get that phone number?
I found it on their website, and I understand they're not answering the phone at the moment, but they're out of the maps anyway. But theoretically, they're $10. You can order one, and about the time this ban is ended, they'll have the maps to tell you where you can't go. Stop a forest ranger if you're going out in the boonies, if you see a U.S. forest ranger, and ask them if this area is okay to shoot in. Because if it ain't, it doesn't have a lot of trees to be the forest.
That's right.
So make sure the guy says, yeah, it's okay, because he knows where the areas are. This is federal guys, U.S. Forest Service, to ask that question to. Washington Times said on July 6th, the NRA carried it also. The FBI said so far this year in 2017, there have been 12,601,102 background checks as of 2 days ago. 12,600,000 background checks. That roughly means 12 million guns sold, because you do one, get 2 guns, and some people, do different things. 67% of the people said they were buying the gun for protection. 38% for hunting, and so on and so on. People are buying guns. We may actually surpass 2016 for number of guns sold. It ain't Hillary, it's crime.
That's
Hillary ain't there. The gun rush was never caused by Hillary's blustering. It was caused by crime. Coming up, gun show, Western Trails Gun and Knife Show is at the Texas Station, June 8th this weekend. Rancho in North Las Vegas. Y'all know where Texas Station is. Don Green will have a table there.
Yeah, we'll be there.
And answer all of your questions.
If I can, yes, I'll answer your questions.
Because if you got a million of them coming off of this show, we just don't have the airtime available to do this kind of stuff. It is now 6:00 next week. I have murder defense attorney Clark Patrick on the show with me. We just worked a case together, and I don't think we want to talk about that one though. We will be back next week. We're right up on 6:00, so we're right up on our time. We needed more time, but there's a lot of stuff here. Go by the gun show and talk to Don. This is going to be a really in the woods thing.
Yes.
Check your gun trust. Don't go out shooting in the woods without talking to a forest ranger. Big fines. All right. Thank you for watching Fired Up.
Thank you,
I'm
Bob.
going to now click the little button on the bottom that says we're going off the air. Have a great weekend. Thank you for listening.
Thank you.